And yeah, thank you all for joining us today for the third installation of our series on supporting the growing Guatemalan population in Chester County. The purpose of the series is to offer culture-informed practices on how to better understand and serve our Guatemalan neighbors. And I thank you for spending your time with us. We hope that you have a lot of questions for our panelists, and we're going to devote the second half of the presentation to questions and answers. So please be sure to ask any of those questions in the chat as you think of them, and we will try to get to all of them. Just please be aware that to not ask super personalized, specific questions. This is more of an overview, and if you do have any of those specific questions about a specific case, you would need to reach out to one of the attorneys privately. Also, please note that I will not be able to respond to any direct messages sent to me. So please send them to all in the chat. And also, please be sure to keep muted to avoid background noise during the presentations. So if everyone can just make sure they're on mute. All right, and yeah, we have a lot of information, so let's get started. And I would like to introduce our first speaker, Lindsay Sweet. Lindsay Sweet is one of the founding partners of Sweet and Pacioric LLC and manages the Avondale office of the firm. She has worked defending immigrants' legal rights since 2006 and has been licensed to practice law in the states of Pennsylvania and New Jersey since 2009. Her firm focuses exclusively on U.S. immigration and nationality law and has clients worldwide. A native of Kennett Square, Lindsay has also lived and studied in Veracruz, Mexico in 2003. Lindsay graduated from Haverford College, and prior to attending law school at Rutgers School of Law, Lindsay worked with the Pennsylvania Migrant Education Program for 4 years, providing supplemental education to the children of the migrant farm workers in Chester County. Lindsay has also served on multiple liaison committees of the Philadelphia chapter of the American Immigration Lawyers Association, including as current liaison chair to the Office of the Public Legal Advisor. She is very involved in the community around her and is vice president of the board of the Maternal and Child Health Consortium. So let me just pull up her PowerPoint super fast. Okay.
All right, great. Thank you so much, Emma, and thank you for the invitation to speak today. Today, I really wanted to share with you as my piece what, to the best of my knowledge as to today, because this is changing on almost a daily basis, and I'm sure that our other panelists can attest to that, what the potential life cycle of removal proceedings for some of our families could look like. Obviously, this is going to be generalized, but I have tried to create some flowcharts that might be helpful for you in determining where either your clients or your families that you're working with or the children that you're working with, where they might be in this process. And that might shed some light as to what's coming next and what has already happened, which will make you better able to work with them. So next slide, please. So the first, when I'm thinking about the majority of my Guatemalan clients at my Chester County office, the first thing to think about is arrival to the United States. How did the family arrive? And they usually fall into two general categories. Almost all have entered without lawful entry, without inspection, and almost all have entered at the US-Mexico border and were either entered the United States unlawfully and were never discovered and have somehow made their way to the Pennsylvania region, or they entered without inspection and were detained by Customs and Border Patrol near the border and were ultimately processed by ICE, which is the Immigration and Customs Enforcement arm of immigration. Or they also might have turned themselves in willingly, which is what we have seen most recently and almost always for maybe a mother traveling with children or a father traveling with a minor child, that they turn themselves in willingly at the US-Mexico border, are detained for a brief period of time while their case is processed. If their case has some type of merit, or if immigration is unable to process their case because of traveling with a minor child, or the person is removed from the United States expeditiously under something that's called an expedited removal, and that removal would be back to the country of origin, which would mean all the way back to Guatemala. So this is kind of a breakdown of some possible ways that someone might make their way to our region, almost always entering without some type of lawful status, and either turning themselves in willingly or entering without inspection and getting caught once already here in the United States. Next slide, please. So if someone is detained, they could be detained either together in a family shelter for a brief period of time while their case is processed. At this point, we are no longer seeing separation of parents from children, thankfully. So that's not something that will be happening at present. If it is a single adult, he or she may be detained separately, and that may be a longer process, in which case the case may get to the point of going before an immigration judge at or near the border, either a judge located there locally or a judge via televideo from the interior of the United States. And that immigration judge, sometimes referred to as the IJ, may make a determination on release or whether the person qualifies for bond, that it's likely that the person will continue to attend immigration hearings in the future, and that bond secures their attendance. The hearing is, the first hearing in a case may have already happened where the bond is set, if there is a bond set, or the case may not have started at all, and the family or individual is released on their own recognizance and told to report to the local Office of Immigration's Enforcement and Removal Operations, otherwise known as ERO. And if you're thinking about, maybe another good chart would have been to give you the branches of the Department of Homeland Security, but ERO is kind of the police enforcer arm of immigration. That's where someone goes to be processed for removal, and it's where someone would go to report to be under an order of supervision, which is the alternative to being detained. So for some of our families that maybe still have an ankle bracelet or are reporting on a monthly, weekly, bi-monthly, bi-weekly basis, either by phone or in person, they are reporting to either the Philadelphia or Dover Office of Enforcement and Removal Operations or one of their subcontractors. So when they're released on recognizance, that means that their case probably has not been started yet, and they don't have a hearing date at the time that they have been released, and they may be reporting to the local ICE office for continual review, that they haven't gotten in trouble, that they have an established residence, that they have a phone number, but their actual immigration case may not yet have started. So they're kind of one of two paths. Either the case started at the border, in which case it may have, there may already have been the first hearing, or the case didn't start at all before the release, and the person is still waiting for their case to be processed, but locally here in the Philadelphia Immigration Court, if it's someone who resides in Pennsylvania or Delaware. Next slide, please. So the next slide is where a lot of our families are awaiting their first hearing. Many who entered during the period of 2017, 18, 19, and sometimes even into 20 and 21, their hearing may not have actually, their first hearing may not have actually happened yet due to delays in processing within Immigration and Customs Enforcement, delays in processing within the Executive Office for Immigration Review, EOIR, or the Immigration Court, as we're going to call it. So there could have been delays that have prevented this whole process from even starting, and they may be awaiting that first hearing still to this day. I refer to in this slide the NTA, and I apologize that there are a lot of abbreviations in the immigration world, but NTA refers to Notice to Appear, which is the charging document that Immigration and Customs Enforcement fills out alleging why someone should be put into removal proceedings. And that is the document that is served on the immigration court in order to start the process. So it's kind of like the complaint or the affidavit of probable cause. It's the charging document. So that is needs to actually be served on the immigration court in order to start the process of removal proceedings or hearings. And as I mentioned, there are many cases where families have been here for quite a long time now, some as many as 5 or even 6 years, where those documents have still not been served on the immigration court, and the family is in limbo waiting for that document to finally be served on the immigration court, if it is at all, because there are some cases where it just may never get filed. If that document is filed with the immigration court, there is an obligation to update the respondent's mailing address with the immigration court, so that when there is a hearing notice issued, it is sent to the correct address. And also where the first hearing notice is sent, it's sent to wherever they're currently residing. It's important to remember that if there was a hearing at the border before the family moved or the person moved here to our region, that the hearing might still be set at that border immigration court, in which case there's going to need to be a whole bunch of maneuvering to get that case transferred up here to Pennsylvania. So it's important to see where the case started for that reason, because someone might miss a hearing without even knowing it, because they thought the hearing was automatically going to be sent up to our region when it never was. And as I mentioned, also, there are a lot of families and individuals where their notice to appear just has not been filed with the immigration court, and they're sitting in this limbo, and they need to be constantly checking the EOIR or the immigration court case status to see when their first hearing is going to happen. They may also still be continuing to report with the local immigration office, which is not the court. They're two separate entities. The police arm and the court arm are two separate entities. They may still be reporting with the police arm of immigration without actually being in immigration court yet. Next slide, please. So I put here, just as a reference, the EOIR, the immigration court, has finally entered present technological times and has created a way for someone to be able to check their immigration court status online, as opposed to this antiquated 1-800 number, which had been used for decades. The 1-800 number still exists, and I put it there on the screen. But there's also a link to the actual website where anyone who has access to their A number, which is the identification number that every immigrant that is processed by Customs and Border Patrol in this process that we're talking about will have. It's their identification number. It always starts with the letter A. Most of the new numbers that are issued for newer arrivals start with the number 2 as well, and then it's 9 digits in total. That number is going to be needed to be able to enter it on this website and be able to check the status of the case. And this website is what is most often updated on a daily basis. I think at this point, its information is more accurate than the phone system that I'm not sure is updated on a daily basis. Maybe Christina can comment on that later, but this is the best way to get the most accurate information, that or actually calling the immigration court. But if we're talking about a family trying to do this on their own, this would be the way to do it. The website, it can also be in Spanish. I don't know if you see there on the site, it says in English now, but there is a drop down to make it be in Spanish. And this can be checked even from a cell phone. Next page, please. So now let's assume that the case is before the immigration judge and the family or individual is going to have their first hearing. All of the initial hearings are called master calendar hearings, often referred to as an MCH. It's kind of like a cattle call where a lot of hearings are scheduled at the same time before the same judge, and they are heard in the order of their arrival. But there's a lot of waiting. And now if you are pro se, meaning that you do not have an immigration, you don't have an immigration attorney representing you, you don't have legal representation, all of the hearings are back to being in person. And all of those that are not represented by counsel are heard after those that have counsel. So there's a lot of waiting because everyone has the same check-in time. So let's go down the tree of I don't have representation and I'm going to my first hearing. What's going to happen? It's important to remember that the majority of those in removal proceedings ultimately never have legal representation. It's still over half of those in removal proceedings never have an attorney working on their case throughout the entire thing. So the one option is that someone ultimately decides to proceed on their own. They can't afford to hire an attorney, or they can't find a nonprofit that can represent them, and they may end up proceeding in removal proceedings, which is what this is, on their own. The other option at that first hearing is to indicate to the judge that I'm looking for an attorney and I need a little bit of time to find an attorney, and the judge will give an initial continuance in order to find legal representation for that next hearing. And that also will grant the attorney time to prepare for the next hearing together with the client. If the respondent already has an attorney, at that point, the immigration judge is going to begin to expect to see some movement in the case. It may be that first hearing is just to declare what the relief will be, and we're going to talk about what the relief might be. Or the judge may already be requesting a response to something that's called a scheduling order, which is where the immigration judge would ask, a declaration of what the relief is going to be, submit the application, all of the supporting evidence, and have that due to the court before a certain deadline. Alternatively, there is the opportunity under the current administration to request what's called prosecutorial discretion, which means that in negotiation with the Office of Chief Counsel, which is kind of the prosecutor arm of ICE, it might be possible to request that a case either be terminated, meaning that it's thrown out, or be administratively closed so that the case no longer is on the active calendar. It's just put in the cabinet, in the filing cabinet, and there are no longer active hearings, but the person is technically still in the proceedings, but not actively. Or there might be an agreement to some type of relief, but there is now the ability to have that conversation with the prosecutorial arm of ICE and see what options are available for individual respondents. In a lot of these cases where we're talking about recent arrivals, that may or may not be an option because we're still waiting for more detailed guidelines as to who qualifies for prosecutorial discretion and who doesn't qualify for prosecutorial discretion. There was a memo that was issued in 2021 that was supposed to provide guidance as to who qualified and who didn't qualify, but there has been really a not standardized approach as to how that applies to individual respondents, and some offices around the country are offering it to certain respondents and others aren't. So we're at this point awaiting further specific guidance as to who qualifies for their case to be terminated or closed, or to agree to some form of relief. And then I also mentioned, just on this tree, it's important to remember that not all cases have some form of relief. We, as attorneys, we try to be as creative as possible to find some form of relief for all of our clients, but it is possible that in some cases there just isn't relief available, in which case ultimately the case will end at some point after as many continuances as we can request. The case will end, and there might be a need to take voluntary departure or be actually ordered removed from the United States and physically removed. So that's kind of the other half of that tree. Next slide, please. The merits hearing. So ultimately, after any number of master calendar hearings or kind of preliminary hearings, the case ultimately will come to what's called a merits hearing. The merits hearing is an individual hearing. It's closed to the public. It is where the respondent is going to get to state their case. Their application for relief will be decided by the immigration judge either that day or shortly after, if the immigration judge needs to review documentation or look into the ultimate decision. But that's the final hearing in a case. And it could go one of two ways. Either relief is granted, in which case then there might be additional petitions for family members to now include them in the relief that this individual was just granted. There might be some follow-up with the local immigration benefits office U.S. Citizenship and Immigration Services, known as USCIS, to obtain proof of that status that was granted by the immigration judge. There might be, I mentioned, asylee petitions for family members, children under the age of 21, spouses that were left behind. There's also, I wanted to mention the CAM program, which is the Central American Minors Program, which was initially started under the Obama administration and has been restarted under the Biden administration after being suspended under the Trump administration, which allows minors from the Central American countries to join their family members in the United States if they have pending relief. And I don't want to get into all the different types of relief, but it is a pathway to have minors join their family members here faster than the traditional routes and not have to come illegally to the United States. So that is open and running at this point. So there's also the possibility that relief could be denied. And if it's denied in full, meaning that you applied for several things and everything was denied, there's the opportunity to appeal that decision if there is some type of merit for that appeal. Or the other option would be to accept that the case was lost, and either, if you've requested voluntary departure, leave voluntarily, or accept the removal order and ultimately be deported from the United States at government expense. If the case was partially granted and partially denied, then that's a strategic decision as to whether or not it makes sense to appeal the part that was denied, or whether someone is happy with the relief that they got and just let things lie. And it'll also depend on whether or not the government was in agreement on the part that was granted. But the merits hearing is kind of where the rubber meets the road. It's where the immigration judge is ultimately going to make the decision. It's where testimony is given. It's where the respondent is cross-examined by the prosecutorial arm of ICE, of Immigration and Customs Enforcement. And it's ultimately what the entire case has been leading up to and where it ultimately ends, usually. Next slide, please. So I think I'm going to breeze over this because my understanding is that Christina is going to talk briefly about asylum and also special immigrant juvenile status. I had put in a few slides about what relief might be available for recent arrivals, because it is limited relief given the recent arrival and the way of arrival. But so we're going to skip over this slide and also this slide. Okay. I do want to mention, since I'm not sure whether anyone else is going to be talking about this, that it's always important to think not just about the recent arrival or the person in removal proceedings as to what their relief might be, but also think about ancillary relief or relief that may have they may be available, that they may be eligible for, that was triggered by something already in the United States. So it may not be why they initially came to the United States, but now maybe they're eligible for something else. And that might be maybe someone got married to a US citizen or a permanent resident after they have already arrived in the United States, and now they're eligible for something else that they might not initially be available or eligible for. Maybe they were a victim of a violent crime here in the United States, or were victims of human trafficking. Unfortunately, that happens more frequently than we would like to admit here in Chester County and our community. And it's something that, if a client is working together with an attorney or has a social worker or someone that they can confide in, that information might come out, and that might lead to some other type of a benefit that maybe wasn't initially an option. There also might be other family members that are here in the United States or have been here for a longer period of time, and this new respondent might be able to be a derivative beneficiary on one of their applications. So it's always important to think about the bigger picture. And then there's also the potential, and this is kind of a long shot, but it has happened in several cases, where an employer might be willing to sponsor one of these respondents, and as long as there's not an issue of having been unlawfully in the United States, and that's a whole other analysis that would need to be made on an individual basis, but that's also a possibility that an employer could still sponsor someone for their residency. Next slide, please. Common question: is employment authorized while waiting? And my response is the typical lawyer response, is that it depends. And it mostly depends on whether or not there is some form of pending relief. because contrary to popular belief, employment authorization, and EAD stands for Employment Authorization Document. I apologize for all of the acronyms that we use in immigration, but an EAD or an employment authorization document has to be tied to some eligibility. It has to be based on some type of relief or some type of a status, whether it be permanent or temporary. It does not exist on its own. I have so many clients that come to the office and say, well, all I really want is employment authorization. Can I just apply for that? And as much as I wish that I could tell them that the answer is yes, that's just not, that doesn't exist under our system of laws. You have to be eligible for some type of a status, and then as a benefit of that status, then apply for employment authorization. So there have been restrictions on how long one must wait as an asylum seeker in order to apply for employment authorization. I've heard that that may be overturned and they may be able to apply sooner. That's evolving as we speak, but I just put it out there that as an asylum seeker, ultimately you will be eligible for employment authorization in the majority of these client situations, but it's going to be making sure that the application was timely filed within a year of arrival. There are a whole bunch of other factors that are going to need to be discussed and analyzed prior to actually filing the application. And it's important to note that although none of us here as licensed attorneys are going to encourage anyone to engage in unauthorized employment, it is important to note that unauthorized employment in the United States does not disqualify an applicant for humanitarian relief. So it's not going to make them ineligible. So we know that our clients need to survive and they need to do what they need to do to make that happen. Next slide, please. And just kind of in conclusion, I wanted to mention at least what I see in my practice as some specific obstacles that I see in Guatemalan cases that are not present in all cases. Interpretation, I know that this is going to come up, and I think that Danielle is talking about language access. Interpretation is often required in order to get accurate storytelling. And accurate storytelling is absolutely necessary in order to present a case to an immigration judge. And family members cannot and should not be used as interpreters when we're talking about very sensitive topics, such as having been a victim of domestic violence or other sensitive topics. And unfortunately, when we're talking about some rare Mayan dialects, or if there are no other interpreters available, that can be a factor that creates either distance between the client and the attorney, or just that the case is not able to be presented in the way that other cases would be if there were not that language barrier. Corroborating evidence sometimes just doesn't exist, or it's just not able to be obtained, and yet immigration judges expect that you're going to present that evidence. So you need to make sure that the client has an explanation as to why that evidence is not available. Something that I have seen personally is that a lot of domestic violence and treatment of women as property is often internalized as normal. And so when we talk about having been a victim of domestic violence, some women don't see themselves as having been victims because that's just the way things are. So sometimes it takes for lots of conversations, months, possibly even over a year of conversations in order to even get to the point where a client might see themselves as having been a victim or continuing to be a victim of domestic violence. And they may never, to be very honest. And also going back to accurate storytelling, a lot of times we see that internalized trauma creates circular timelines. Clients are unable to get their story out because they're unable themselves to remember the timeline of events due to trauma that they have themselves suffered. There are a lot of mental health issues for those that have been victims of severe domestic violence or other violence in their home countries. And sometimes it may, we may be the first ones that are hearing a story, or, a psychologist that we refer someone to, or a counselor that we refer to someone to, that might be the first time expressing this outwardly. And it takes a long time to decipher that circular storytelling. And then the last point is that nonprofits that do this type of work are overwhelmed, and for that fact, are only able to take the most meritorious cases. And so there is a need for private counsel to do this type of work because there is no court-appointed attorney that's going to represent these respondents in removal proceedings. So all of these factors make particularly Guatemalan cases in our community more difficult, and some of the most rewarding cases that we work on, but also it's sometimes a struggle. So I think that's the last slide. Yes, thank you.
Yeah, thank you so much, Lindsay. And like I said before, if anyone has any questions about anything that Lindsay just touched on, just enter them into the chat so you don't forget them, and we'll get to them at the end. But yeah, thank you so much. And let me pull up the slides. Our next speaker will be Daniel Cortez, and he is a native of Colombia and a resident of Berks County, and he's based out of CIP's Reading office, preparing DACA applications and advancing the rights of the immigrant community in Pennsylvania. Danielle works with the immigration unit on general immigration matters, community education, and immigrant rights. And he graduated from Reading High School in 2008, Kutztown University in 2011, and Florida International University College of Law in 2019. And after graduation, he worked at Legal Aid of Southeastern PA on expungements and other civil cases. So let me pull up your slides really quickly.
Well, good afternoon, everybody. While Emma's pulling up the presentation, pleasure to chat with everybody. I definitely encourage people to ask questions because I feel like people have more questions than we have answers to. So I think if we can get you the information, we'll find somebody that will. But this is important for you guys to let us know to what type of information that y'all need. So I mean, you could just go to the next slide. I'll just go right into it. I'll be brief. I wanted to talk a little bit about the sponsor versus the guardian. What we've been seeing a lot with the recent arrivals is that the Office of Refugee Resettlement will need what's called a sponsor. And in immigration, a sponsor could be a lot of things. So in terms of the recent arrivals, when you hear somebody has a sponsor, more times than not, it'll be somebody that is taking responsibility for this recent arrival, whether it's a minor or whether it is an adult. And compare that to a guardian, that's more of a concept of a state law and responsibility. So I definitely wanted to start talking about the difference between that. So on a state law, your guardian is more of the actual state court saying that this adult has legal custody, legal power over this minor child to make XYZ decisions. And so normally for you to be a guardian, if you're not the biological parent, that's something that you have to get a family attorney for. Some immigration attorneys do both family and immigration law, but a lot of the times you will see that some of these recent arrival minor children will need a family attorney and they'll need an immigration attorney. So I think that that's important to delineate. That family attorney will be able to get that custody of that abuela or that uncle or whatever family member that's taking care of the child, and really help them be able to get them enrolled in school or get them to attend to their medical needs or whatnot. Some minors have their parents send documents from their countries giving some sort of power of attorney to these guardians. That's another way of doing it, and you'll see that as well. And then when it comes to biological parents, you obviously just, in a lot of places, show the birth certificate, and then that's why you can get away with having those parents do a lot of those decision makings. But the sponsor, for immigration purposes, has different responsibilities. They don't go to a state court and say, I will be responsible for this person. That contract is rather lax. It's really just an adult signing a paper saying that I will receive this individual. And so if we could go to the next slide, I'll talk about the responsibilities. I get this asked a lot. Some people are very hesitant to be a sponsor, or you might want to find out what is the responsibilities of a sponsor. So in the documentation that a minor child or a recent arrival will get, here's some of the responsibilities of the sponsor. It's basically so that immigration does not have to house or be responsible for these individuals. They would prefer to have these minor children in the home of a family member or somebody they know. And so that sponsor will fill out an application. They'll have to submit their information. Immigration might do a background check. You need to prove some sort of relationship that you have with this child. And after you do that, they'll get these responsibilities. You have to take care of the child. It also says that they do want you to establish legal guardianship within a reasonable time. So again, getting that family attorney and doing that. They have some paperwork on attending an orientation program, and they have a whole packet on things that you should do. And you're also ensuring that this minor child is going to attend their immigration proceedings and make sure that they are on top of things. And notifying authorities if that minor is being subjected to abuse, abandonment, neglect. They have the hotline that they should call if they're no longer responsible for this child or unwilling or unable to take care of that child. And that link to the handbook is there. It has all that information. I haven't heard a lot of cases about sponsors being held responsible for children. Because I think it's more of lack of resources on the federal and state government. But I want to be clear that there is still liability and responsibility there. And so I've gotten calls from multiple sponsors where they'll sponsor a child, especially a child that's like 16 or 17, and then they run away with a boyfriend or a girlfriend, and they're no longer responsible for them. It is very important for them to cross their T's and dot their I's. They should call the police, make that report, let them know that that child is no longer with them. Call the 1-800 number at ORR and let them know that that child is no longer with them. So that if something happens to that child or anything happens, CYS gets involved, that sponsor basically did everything that they reasonably could, outside of like physically grabbing the child and making them sure that they're living with them, right? Because there will be those situations where it's just not clear whether that child wants to be there. The sponsor and the child relationship could just vary from time to time. So I definitely recommend that if you have any of those situations, make sure that the sponsor is on top of that. Next slide, please. Okay, and so somebody else is going to talk about the juvenile visas, from my understanding, but I wanted to talk about the importance of these family attorneys. If the child is alone, really be cognizant of the timeline. Once they turn 18, they will no longer be eligible for a juvenile visa. And that is a deadline that I see way too many people miss. And so just have it on your radar. If there's anything that you hear from me, if that child does not have either one or both of their parents with them, make sure they get screened for that juvenile visa, because it takes time. It's going to take resources. Like Lindsay said, the organizations are swamped and the private attorneys are going to have a price for that. And as we know, it's going to take some time for these families to get these resources together. So if you're getting an attorney, that if a child's going to turn 18 in 2 months and they go to a private attorney, that's going to be really hard for them to do this. So get it early and really screen for that situation. The other thing that Emma wanted me to talk about is the embassies. We struggle with our families to get passports, documentation from the embassies. Immigration sometimes does something that I've never gotten an answer to, but they will take the passports of recent arrivals, and they'll just withhold them from them. So it's really frustrating for individuals that come here because then they think that they can't get another passport. But they need to contact their embassy because you need some sort of identification for many, many purposes, including immigration. It'll help the individual's case. For Guatemala specifically, they're a little tricky, but there's the link. You need to get an appointment. As of 2 weeks ago, the appointments were Friday at 4 p.m. I checked this week, and now they're Monday, Wednesday, and Friday at 8 a.m. So you have to go on that link, and certain slots open up at each of those moments. When I tried it 2 weeks ago, the slots all filled up within like 5 minutes. And so if anybody needs an appointment with the embassies, make sure one, you go to their website. That link has the link here has a link to all the embassies in the US, all foreign embassies in the US. And then for the Guatemalan embassy, I got the link right there so that you can go tomorrow morning, even if you wanted to at 8 a.m., be there at 7:50 in front of a computer. All you need is just your name and the time. So that's that helpful hint. If anybody has issues with embassies, I'm more than glad to connect. Sometimes I know that the lawyers have emails and relationships with the embassies. It could be really helpful. Because I know, for example, with the Mexican embassy, if I write a letter stating that I really need this documentation, they will expedite that. So don't let not having documents be kind of just a deterrent for terrible things. I mean, a deterrent for them being able to do it. Make sure that they ask, and we're here to help. Next slide, please. Okay, and then I also want to talk about a little bit about the child obstacles. I know that truancy has been an issue with my clients. Again, the recent arrivals, I hear more times than not that they want to work, especially if they're closer to that age of 18. I think that really coming in with an open mind and understanding where they're coming from will advocates and caseworkers and educators will be able to find more proactive solutions. But I understand that it's difficult. I had a parent that they were charged for truancy because the child just refuses to go to school, and he's just like, what do you want me to do? The child is safe, but he just wants to work. And so understanding that dilemma, I think is critical. I don't think that it's realistic to expect that every single child is going to go to school and they're going to pay attention the entire time and they're going to get their needs met. The system is just not designed that way. So try to just go with an open mind with that. And that goes to the second point. Building relationships is critical, because if you build relationships with the child or the children, maybe getting a GED could be a more realistic path for a child that arrived, especially close to that 12th grade year, and then getting them on some English classes at a local organization so that they could do at least their ESL, they could work or whatnot. And so creating these support groups at school, sharing those community resources that really go outside of the box is critical. And then my last point is language access. I can't stress language access enough. It's not the easiest thing in the world, but I'm going to try to share what I know on the next slide. So if you could give me the next slide, please. So first of all, I've been telling everybody about Tarjimly. It is an amazing app. It was made by refugees. It is a free translating client-facing app by volunteer translators. And so anybody with a smartphone can download this app. And if I need to talk in like Farsi right now to somebody, I can say from English to Farsi, and they will get me a translator that's a volunteer translator that's screened, and they will be a live translator. And if I need to get out of a bind, I can do that. I could also has a function to send pictures, messages. So if I get a form from immigration and I have no idea what it says, I could take a picture of it and a volunteer translator will translate that for you. And so that's really great to share with parents and minors, because we know that all the spaces that they interact with don't have those translators. And so for nonprofits as well, I know that there's a lot of nonprofits. It Targemly also has a paid service where it's $25 a month per user. I think that is very, very inexpensive, and it's only open to nonprofits. And so I know that nonprofits normally have to pay per minute of translation services, and that could just rack up. So if Targemly has like a language that maybe that you don't have staff or it's not accessible, I think that'd be a great investment. It's very economical. They're really, really working to create access because like I said, refugees created the app. They're run by client-facing individuals that know firsthand what it's like to not know that language and have to navigate the system. So that's the first plug. Installing Google Translate extension allows you to translate any web page into different languages. That's a link that you could share with parents, with students. You can go to any single website on the internet and you could translate to any language that Google has. It keeps the formatting and everything. In terms of YouTube videos, anybody could watch a YouTube video and it'll have subtitles. Most YouTube videos have the technology to read the audio and then generate subtitles, and then you could generate subtitles in whatever language you need. So if you found a great immigration video, or if you found a great inspirational video, but it's not in Spanish, they could just watch it with those subtitles. It's great. The other thing is you can translate documents and keep the formatting using that that link. It's called DocuTranslator. You could have a 50-page document, and if it's in English, you could translate it to Spanish in a matter of seconds or minutes. All these automated translation services are obviously through technology. They have their glitches, they have their mistakes. The most ideal way to use these types of resources is to have a bilingual person that at least proofreads what the generator generates. But instead of paying somebody outright to translate a document from scratch, that DocuTranslator will save you, I would say, like 90% of the time. So that could mean a lot of money and resources for organizations that have to pay for the translation services. And it's also very easy for students or any immigrants to use if they can navigate that translation. The other tip is, like, if you're stuck, you could Google it, because resources are constantly changing. I mean, there could be some sort of app, some sort of new technology right now that that's released, and I have no idea about it. So constantly, yeah, I could do the links. So constantly look for things. And then also share another great app. It's through Microsoft. You could create group chats with different languages. And so if you need to communicate with a parent in a different language, if they download the translator app from Microsoft and you do, you'll basically speak in English, and then it'll translate to whatever language they have, and then they'll speak in whatever language they're speaking, and you'll get the messages in English. And it's a group chat, so you could have dozens of people in that chat. So that's also a neat application. And so there's a lot of benefits to this stuff, and I wanted to share with that. So more than happy to talk with anybody one-on-one if they're stuck, if they want technical assistance on this. I really enjoy making people's lives easier, so you let me know. Next slide. The other thing is, I found these 6 nonprofits. I would just recommend just pick one, and then I could put the links again, and join their listserv. I think that being Immigrant Rising, I would highly recommend, or United We Dream. Being on listservs for these organizations, you don't have to open every email that they send, but but I think that just being aware that, like, if United We Dream says, hey, here's a DACA update, at least you kind of just feel like you're up to date with what's going on. You never know. Immigrant Rising provides scholarships to undocumented immigrants. Right now, obviously, access to higher education for undocumented students is so difficult, but we here in Berks County, for example, we've created our own private scholarship for undocumented students. And this year we have undocumented students getting full rides at Swarthmore, Lehigh, Cabrini, Gettysburg. I mean, these students are just fully undocumented. They don't have a social, they don't have anything. And they're getting full rides to these universities. And then there's these other organizations that will supplement with scholarships. And so if you really have brilliant students that their immigration case just doesn't look great, or there's just no kind of just light at the end of the tunnel, these organizations will definitely support you. And so if you have any students in that situation, I'd be more than happy to help. I was an undocumented student myself. I went to Kutztown fully undocumented with private scholarships. And so it's possible. It's just very difficult. And unfortunately, the numbers just aren't where I think we should be. And so advocates like you could definitely mean kind of just the difference between a child really succeeding in one of these institutions or not. And so if you have bright students, please let me know. I'd be more than happy to kind of guide them through the complicated system of higher education as a dreamer. And I believe those are all my slides, if I'm not mistaken.
Yes, thank you so much. And would it be okay for me to share those slides with people so they can have those links? Okay, great.
Share with the whole.
Awesome. Thank you so much. I think that was a lot of really good links in there. So, and also really good resources. Yeah, and then our next speaker, who's our final panelist, and then we'll open it up for Q&A, is Christina Galvan. And she is an immigration attorney located in Kennett Square. She is a first-generation US citizen, born and raised in Kennett, and her law firm also has offices in both Philadelphia and Collingswood, New Jersey. After graduating from Kennett High School, Christina went on to study political science and Latin American studies at Temple University, and then attended law school at UPenn. And she has been practicing immigration law since 2009. Christina has extensive experience with deportation defense, special immigrant, juvenile petitions, family-based applications, including waiver applications, asylum applications, abuse-based petitions, naturalization applications, and non-immigrant visa applications, including U visa applications. So I'm going to share your slides.
Thank you, Emma.
Yes, and whenever you're ready.
Sure, thanks. So I'll try to be quick so that we have time for some questions afterwards. I am going to talk about some potential immigration relief for minors. I will say from the beginning, so a minor can apply for anything that they're eligible for with immigration. But today I'm going to talk about the two most common forms of relief that we're seeing with the recent arrivals, which are special immigrant juvenile status and asylum. So if you could go to the next and then the next. Special immigrant juvenile status, which Lindsay and Daniel touched on very briefly, we call it SIJS. It basically allows a minor child to apply for a green card without having a family petitioner. So most things with immigration, you need a family petitioner. With SIJS, It's a form of relief where the minor can get that green card without having someone petition for them directly. It's a self-petition. The minor can apply affirmatively or defensively, meaning if they are in removal proceedings, the process that Lindsay talked about, they can apply for this. If they are not in removal proceedings, they can apply for this. So if they came in through the border and were never caught by immigration, they can still apply for this. If they came in on a visa and overstayed, they can apply for this if they're eligible. There are 3 basic steps to this process. The first being the predicate order, then the actual petition, and then the green card petition. And I'll briefly go over them just so basically you guys are able to issue spot with some of the children that you're working on. And then if you think they might be eligible for something like this, you'll kind of know when to point them to an attorney, or if they're already in this process, you'll know a little bit about it to know like where they stand and maybe why they're doing some of the things that they're doing. So next slide, please. So the predicate order is basically here in Pennsylvania, it would be a custody order from the Court of Common Pleas from your county. The predicate order, the custody order from the family court has to have certain findings in it in order for it to be used with immigration in the future. And so those main points that the custody order needs to hit is that reunification with one or both parents is not viable due to abuse, neglect, abandonment, or similar basis. So most of these cases that we're seeing will be abuse or abandonment or some sort of combination of those. And it could be against one parent or both parents. So if a child is living with one parent, they can still qualify for this. They don't have to be away from both of their parents. It could be one parent filing for custody, or it could be someone who's not a biological parent filing for custody. A lot of times we're seeing older siblings, an aunt or an uncle, someone else filing, even a foster family filing for custody in order to get this order. The order must also state that it's not in the child's best interest to be returned to their home country. And I always tell people, I'm an immigration lawyer, I don't do family law, but it's very important to have a family lawyer involved in this process, because if any of these points aren't hit on that custody order, immigration is going to send us something back saying this order doesn't qualify, and then we'll have to get an amended order, which takes more time, more resources for the family or for the child. In Pennsylvania, as Daniel noted, in Pennsylvania, these custody orders are given up to the child's 18th birthday. So in Pennsylvania, these orders have to be petitioned for in a timely manner so that you have it before the 18th birthday. Other states do go up to 21. For example, in the area, New Jersey and New York will both do custody hearings up to the age of 21, but Pennsylvania does them up to the age of 18. Next slide, please. Once you have the custody order is when we would be filing the actual petition with immigration. And those are filed with USCIS, which is immigration. And whether they're in court or not, whether it's affirmative or defensive, only USCIS has jurisdiction of these petitions. So it would go straight to them. And those petitions need to be filed before the child turns 21. So in Pennsylvania, we normally don't have an issue with that since they've gotten their custody orders prior to 18. Most cases would then quickly file to do your petition. So you're below the 21-year age limit. But if they have a custody order from another state, you just want to make sure that you get the petition filed before they're 21, because that way they keep having protection. Even if they turn over 21, they will still have the protection from the I-360 being timely filed. And another important note is they must be unmarried. So a lot of times with some of the older kids, if they're in a relationship, we always warn them, you cannot get married during this process, or it will basically stop the process from being able to go forward. A new development is that immigration is going to start granting children with these deferred action, which means that they'll be eligible for a work authorization, an EAD, which is new and important because before you had to wait a long time for that to happen, because you have to normally wait until you file for your green card, which would be the next step after your I-360 is approved. We could do next slide. So the last step in this would be filing for your green card. You can normally, before at the big wave of recent arrivals that came in like 2016, you were able to file your green card at the same time. That's not normally the case now, especially for the recent arrivals from Central America. These visas are subject to annual quotas and they're based on country of origin. And so the time that it takes to file your green card application will depend on what country you're from and will depend on when you filed your initial I-360 petition. But once your priority date is current and you file for your green card, you either file with the court if it's a child who's in removal proceedings, or with immigration if it's a child who is was never in removal proceedings or proceedings were terminated to do this process. And again, the child must continue to be unmarried. And if they haven't gotten an EAD from the petition stage, then they can now apply for one. Next slide. I put in this month's current visa bulletin just to give you an idea of how long the wait is for these types of green cards. So these petitions, the SIJ petitions, fall under the 4th preference category. So you'll see El Salvador, Guatemala, and Honduras. For this month, they are on May of 2017, which means if someone were to file that I-360 petition this month, they've got about a 5-year wait to be able to get the green card or apply for the green card. Mexico is a little shorter, April 2020, so about 2 years. And then you'll see all of the other countries with the C, it means they're current, which means technically they could apply at the same time as they apply for their petition. As someone in the chat mentioned Venezuelans, we've seen a couple, an uprising in the Venezuelan families, some Ecuadorian families in the area. And so those children would actually be current to file much more quickly, but the Guatemalan, Central American families are looking at about a 5-year wait. Next slide. Some of the benefits, they get the work authorization and eventually a green card, a pathway to citizenship, that social security number, which, once they are 16, they can get a driver's license, and they have the ability, once they have their green cards, to travel to their home country if they ever want to in the future. But a special note that we always, if it's a one-parent SIJ, always remind them that the child cannot then later petition for their biological parents, even the custodial parent. It's just the way the law is written. So it's a benefit that only the child will receive. Next slide. Some things to look for, when to maybe send them to talk to an immigration lawyer. If the child is turning 18 soon here in Pennsylvania, as Daniel said, a lot of people miss that cutoff line. So you want to send them over to talk to someone before they turn 18. If you have a child who is living with just one or no biological parents, you definitely want to screen those with an immigration attorney to see why they aren't living with both parents and if they might be eligible for an SIJ green card process, or children currently in removal proceedings. So children currently in removal proceedings, you always want to be able to get them any relief that they're eligible for. So they definitely should talk to an immigration lawyer to see if they're eligible for this. Next slide. And then the other big one that we're seeing recently is asylum. So I have the law there, but basically asylum would be for someone who is afraid to return to their home country because of past persecution or fear of future persecution. And it has to be based on race, religion, nationality, political opinion, or membership in a particular social group. Most of these cases that we're seeing now with the recent arrivals will be membership in a particular social group. So the domestic violence-based cases, the gang-based claims, any other family type relationship basis for asylum would fall under that particular social group category. Next slide. And again, just like SIJ, they can be filed affirmatively or defensively. So you can file this if you're in court, or you can file it if you're not in court. The important thing is that you have to file within 1 year of your arrival. There are what they call extraordinary circumstances to this rule, which one that courts have found is if you entered as a minor You're not necessarily always expected to file within the year, as long as you file shortly after turning 18. And a good rule of thumb that we like to use is about 6 months. That way they're not accruing unlawful presence, and you get it, your application in quickly after they turn 18. That would more so be for an affirmative type of case. If it's a defensive type of case, like those deadlines might come a lot more quickly, depending where in the process you are. If one of those scheduling orders that Lindsay was talking about has been given, like you'll have other court imposed deadlines. There are special rules for unaccompanied children where you can file sometimes with USCIS instead of the immigration court, which in my opinion would be preferable for a child. The adjudication at the immigration office rather than court is, it's not an adversarial process like immigration court. There's no prosecutor cross-examining you. And a lot of the decisions just sometimes tend to be more favorable to minors at the immigration office over the immigration court. Children can be derivatives on their parents' asylum application, or they can have their own asylum application, or you can do both. So normally we probably do a combination of both. If a child came with their parents and they are eligible for asylum and the child's under 21, they can be included in their parents' application, but they can also file their own application if they have a basis, and that gives them a little added protection of being able to also apply for protection under CAT. That's the Convention Against Torture. It's similar to asylum, but there's no on account of requirement. And so a lot of times if you aren't granted asylum, you might be granted protection under CAT if you can show that you're likely to be harmed in your home country for whatever reason, but you need your own application for that. So a lot of times we'll push families to do an application for, the adult might do one that covers the whole family, but then each child should also do one of their own so that they can apply for CAT. And as Lindsay touched on, when you are applying for asylum, generally after about 150 days now, you should be able to apply for a work authorization card, which will give you something while you're waiting for this process to be finished, because it is a long process. There are a lot of backlogs in both the asylum office and the immigration courts locally. Next slide. I put in these asylum statistics, not to be a downer, but just to, so you kind of see what some of these families are facing. So the national average for the last fiscal year is at a 63% denial rate, meaning that only less than 40% of cases are granted nationally. And I did throw in the Philadelphia Immigration Court. As you can see, a lot of the judges have even higher denial rates, up in the 70s. Asylum is very difficult to obtain. There's a very high threshold for the on account of a particular social group. And so if you are eligible for something else, such as SIJ, we would always advise the family to even do both, because you might have a case where parents are filing for asylum and they've included the children, but if they have a basis for SIJ, if they're only living with one biological parent, you would do both. You would do an asylum for everyone, but you'd also do an SIJ so that the child would have additional protection if the asylum application is denied. Next slide. So what to look for in trying to screen for asylum cases are recent arrivals to the US. So a lot of the recent arrivals are coming here because something has happened in their home country and they're afraid to return, or if they've given themselves up at the border, they might have already had what's called a credible fear interview, where they've already started the process and told immigration that they're afraid to return to their home country. So a lot of recent arrivals are applying for asylum or are eligible to apply for asylum. Again, children in removal proceedings, and children not in proceedings but nearing their 18th birthday, so that you make sure that if there is a basis for asylum, they file quickly after they turn 18 so that it's seen as a timely application and that they don't accrue unlawful presence. Next slide. I just threw in some other potentials. So those are the two main big ones, but there are other things that they could possibly be eligible for. The prosecutorial discretion that Lindsay talked about, U visas if they were victims of a crime or if their parents have been, VAWA if they were victims of domestic violence, T visas, victims of trafficking, or I always like to explain to people it's also workplace exploitation. You know, they might not see themselves as a victim of trafficking, but they might have been exploited in their workplace and might be eligible for T visa based on that, either themselves or an adult family member, a parent. We always advise new families to consult with an immigration lawyer to see what they're going to be eligible for. And there are pro bono resources for defensive cases, although they are very swamped and hard to get into and normally in the city. So there's a lot of access issues, but they are there. I think that was my last one.
All right, yeah, thank you so much, Christina. I think that that was all a lot of really great information, and I know that that there are some questions in the chat already, but if you have any more, please write your chat questions, and Maribel is going to monitor them and ask them.
Hello. I know that some of the questions have been answered in the chat, but I'm not sure if everyone had the opportunity to hear the answers. I want to read them, and if you want to just be able to share with the whole group. One of the first answers were, Lindsay, I think this was for you. Where can the latest guidance be found on, and I'm thinking this was on the first part of your presentation, just as far as.
So it might have been about prosecutorial discretion. I'm not sure. So there was a memo that was issued in early 2021 by the Department of Homeland Security specifying who is a priority for enforcement and removal from the United States and who is not. And then there was a clarifying memo. So there are multiple memos that have been issued by the Department of Homeland Security, which I can send the most recent one to Emma, and maybe can be dispersed to the group. However, we are anxiously awaiting, and I'm sure Christina is nodding, yes, we're anxiously awaiting that there is supposed to be a hopefully final memo with much clearer guidance as to what the Office of the Principal Legal Advisor, the Chief Counsel's Office, the Prosecutor's Office, which cases they should be prosecuting and which they shouldn't be. And hopefully, the rumor is that a lot of our current cases may be thrown out of court altogether. So fingers crossed. And once we get that updated guidance, which we've heard we may receive within weeks, so soon, that can also be shared. But I can certainly send to Emma what we have so far.
Thank you. The next question is, families from Venezuela arriving this year, can they apply for TPS?
So I mentioned in the chat that the current TPS guidance for Venezuelans, that unless there's something else that has happened that I don't know, the current guidance is that the physical presence requirement is that the person have been physically in the United States as of March 9th, 2021, in order to be able to apply. That date has not been changed. So recent arrivals would not qualify for TPS for Venezuelans unless there's a newly issued grant of temporary protected status.
Okay, thank you. Daniela, I believe this is for you. Does the translating do dialects? And I think you put in a link.
Yeah, I would just go to the link because they have all the languages, and then you could just email their support email if you think that there's a need, and then I think that they'll look into that.
And also the response I think you had the chat with is DACA. With DACA, can you file for a green card, or is it just those petitions or proceedings?
Right, correct. So DACA means deferred action. So there's no pathway to legalize for DACA, and so anybody that has DACA they need to find an independent way to get a visa or to legalize. DACA has always been temporary, and unless something changes, will be temporary. But I definitely just a shout out, not a shout out, but I'd be very interested. We've been very interested in PennDOT issues. So if anybody has any families or students that PennDOT does not renew their driver's license, that goes for the DACA, that goes for anybody that has a pending asylum. Because the cool thing about PennDOT is that with the receipt for immigratory relief, certain immigratory relief, you can get a driver's license. And that is just huge for our community. And so it's very complicated. And depending on the PennDOT that people go to, their experiences just vary greatly. And what we've been able to see with our relationship with PennDOT in Harrisburg is that if we tell the situation, we let them know of the situations that people have been experiencing, they kind of get on top of it and make sure that if they are wrongfully being denied driver's licenses, that they will get that. And so when I think of DACA, I think of that because they have to renew their driver's license every 2 years. And it's important that they renew early, but I digress. So we didn't talk about all the types of ways that you could get a green card. I think we selected the ways that are the most common for these recent arrivals, but there is just so many different ways to get a green card or to get any type of other visa. So that's just something that would require a consult with that family or that individual.
I don't see any additional questions.
Carissa,
Oh, wait, the last one.
with
Sorry.
the embassy. Carissa, I
thank
mean, again, the way I did it with my Guatemalan client, I only did this once 2 weeks ago. So maybe I got lucky. But it's on Wednesdays, Mondays, Wednesdays, and Fridays, according to what the website told me. You just have to be in front of a computer with the individual, and you have to click refresh right at 8 a.m. and you have to be ready to pick whatever date they have, because the appointments, from my experience, it was at 4, and at 4:03 they were gone. And so granted, 2 weeks ago, it was only 1 day a week that they were releasing appointments. So if you have the capability to sit down with somebody at 8 a.m. in front of a computer, I pretty know for sure that a lot of these Guatemalan families are not going to have a computer and are not going to be able to type fast enough to put all their information in 3 minutes. So those of you that excelled in your typing class, that'd be a great, I think, support that you can give these families. But the link is there for people to do it 3 times a week, unless anything changes. If somebody's having a real tough time, just reach out to me or email me, and I'll see what creative things they could do.
If I can just add, I put in the chat that I've had some success with clients signing up for the mobile consular operations through the Guatemalan consulate in Maryland, which might be a little bit of a hike, but then it's on the weekends and it's something that can also be scheduled. So I follow them, I follow their Facebook page on Facebook, and that's how I get notified when they have mobile consular operations out there. So that might be a way also to just hear about opportunities where it can be done in one shot on a weekend, and it might be a little bit of a drive, but then it's on a weekend as opposed to a weekday early in the morning. So it's just an idea.
Yeah, and Jim, I mean, great question, right? Again, like, there's the resources just aren't there. So the way I did it, I was on the phone with my client, and I did all the information with my client. So if that's what it has to take, that they need to talk over the phone with somebody that has that internet and that laptop and way to just, click really quickly, that's what have to happen. If you really have, I think, a family that's just really in need, I'd be more than happy to help. It's going to take 10 minutes to make an appointment with them. But again, it's definitely, I think, something that a lot of people can do here. So definitely encourage you to do that. But I want to definitely make you feel supported. I'm more than happy to help.
And if I can just add, that website where you make the appointments, really read it and make sure that the client or the child takes everything with them, because if not, they're going to have to go through the whole process again, because they will turn you away if you don't have everything that they require to get whatever ID that you're looking for, the passport or birth certificate.
Yeah.
So make sure you only have to go once.
And I think that great point, Mari Cruz, in terms of that advocate, really saying, because that's what lawyers do. They say, hey, I really need this appointment. But you as a counselor or maybe an educator or whatever title you have, like, hey, this student needs this for this reason. The embassies, they're human too, right? They're going to be like, that makes logical sense. We need to get this child a passport. The other point, Delfina, with not getting a passport, not being able to get the passport because you do not have both parents. Every embassy, again, has their own crazy rules. This is a challenge. There are children that cannot get passports. There are adults that cannot get their passports because they don't have a birth certificate and they were born in this remote village and they haven't been to Mexico or whatever country they're from in a long time. Again, we have to, I think you need an advocate to try to create a way to do this. It's not going to be easy. So if you have those situations, feel free to email the embassy if you really feel like advocating for this student. Try to really help them out and say, hey, this is the situation. Can they get power of attorney from their country and send it over to the embassy? Really kind of be that advocate. Or if not, I think they might need an attorney to really advocate for them, because we'll have experiences dealing with these crazy situations. But sometimes my clients are stuck. Some clients I'm stuck in that same situation, and so I definitely agree that that's an issue. But I encourage everybody to try.
Does anyone have any additional questions? So as far as having, if people have concerns and being screened to see if they qualify for any of the different ways to be able to stay here, is the first step the nonprofit and then the other attorneys? Or that's often a question that's asked, who do I go to? And being that I do not give legal advice, I connect people to services. I just want to make sure I'm giving accurate information, even if you're fee for service, to know if the screening part is free. Do they have a fee if there's not a nonprofit that has time to hear it because they're overloaded?
I mean, I can go first. So I can put here in the chat, and I don't know whether that's already been shared with the group, but the Executive Office for Immigration Review, the Immigration Court, has a list of kind of recommended pro bono or low bono legal services that include services in Philadelphia, some in Lancaster, across the entire state. So I agree. I mean, I think that if someone cannot afford legal services, then that would be the first place to look and see whether one of the nonprofits will take their case. Again, they don't take all types of cases. It will require doing some type of a consultation, which might mean going all the way to Philadelphia, which has its own costs as well. But that, and most of them are not completely free. They do charge for their services as well. It's just less than what a private attorney would charge. So I think that that's important to know. So I think that's kind of where to start. And then if there is a need to have a case consulted with a private attorney, it would be a question of having a consultation with a private attorney. And I mean, I can say, I'm sure that this is also true for Christina's firm, that we have certain criteria for what types of cases we would take pro bono, and I would need to do an initial consultation in order to make that decision as to whether this is that type of case. Unfortunately, a lot of these families, and I mean, if it's a minor who's alone, that's a different situation. But if it's an entire family, There are a lot of families that are in the same situation, and we just can't do them all pro bono. So it really is going to depend on the particular circumstances. But in general, I do charge for a consultation. I charge $150 for a consultation. It's a 1-hour consultation. It can be in person in Avondale. And, you know, it's at the client's and my availability. But from then on, whether or not we would take the case pro bono or certainly do some type of a payment plan, because everybody does a payment plan, that would be determined personally with the client after the fact. So it would kind of have to be on a case-by-case basis.
That's good information to have.
Yeah, in terms of our organization, we are a nonprofit. We are one of those nonprofits. Like Lindsay said, my supervisor right now has told us not to take any new cases because that's where we're at. Our funding, we have funding for some positions till June. And so it's just the nature of this wonderful world that we live in. But in terms of if anybody, I'm going to put my contact information. The minimum thing that I can offer to people is just general advice over the phone. If you have a client that's stuck, I'd be more than happy to talk with the student. Really just educate them on like what's going on. If like they have a paper from immigration, I don't mind saying, look, this is what immigration's saying, or like, you know, this is how you look up your case. That's all stuff that I'd be more than happy to do, and to really say, hey, it sounds like you have an SIJ case. You need to go invest your time in a consult with Lindsay or Christina, because that's something that, you know, you have a time clock on. And so I'd be more happy to do that or troubleshoot with these embassy issues. So that's something that we could do. And then whenever we can take new cases, I'd be more than happy to take cases if need be.
Thank you.
And for those that might not be checking the chat, I did put the link in there for the immigration court approved list of low bono and pro bono legal services. I can't tell you the last time it was updated. I don't know if anybody else knows that answer, but that's the most recent resource we have.
We appreciate it. Emma, we're 30 minutes past our end time, so I want to check with you.
Oh no, we're ending at 1:30, but we're actually 1 minute. Yeah. So
Sure. Okay.
yeah, so we're perfectly on time. And I think that if anyone else has any questions, if you have Daniel's contact information, Lindsay and Christina, if you want to share yours. I can also share any of the slides with anyone that's interested. I also recorded this, so we have the recording if anyone wants to rewatch. And yeah, thank you so much to our panelists. Thank you for taking the time and spreading that great information, and for all the great work that you do. And thank you everyone else for taking the time to come and asking questions and learning more. I think it went really, really well. And yeah.
Can I mention one last thing?
Yes.
This journey that I think, I mean, this is anything new, but this is exhausting. Like Lindsay's going to send you that list of all the nonprofits, and you know they're going to call 20 people and 19 are going to not pick up their phone call, and then the ones that are going to pick up their phone call say like, we can't help you. And so I really want to inform you that the system is broken. Like most of my clients, I do not have happy things to tell them. And so your role in this job is so critical, because your role could be, hey, you know, we're not going to get you some documentation, but have some food, or here's some health insurance for somebody that's undocumented, or like give them that glimmer of hope that they're still human, and they're valued here in this world. And so I'm more than happy to do that as well, either for you or for whatever students that you feel that are needed. Because when I apply for a U visa and it's going to take 10 years, I think it's like total like ridiculousness. But if I can really kind of just have a conversation with somebody and say, hey, continue working hard, you're valuable, you're much needed in this community. I think that also goes a long way. So definitely thank you for the relationships that you have with these students and these families, and really kind of be that glimmer of hope whenever the system really doesn't validate our existence.
Thank you so much. Yeah, and everyone who's asking for slides, I'll definitely send them to you, and recording, and yeah, I think that's probably a good time to end. But thank you so much, and have a great day and great rest of the week, everyone.
Thank you.